All right, welcome to This Explainer. Today we're exploring one of the most fascinating and, frankly, kind of mind-bending concepts in English law. We're talking about the idea of being held legally liable for what you didn't do. We're going to dig right into the foundations of tortious liability for omissions. It's a journey that is absolutely going to challenge your basic assumptions about responsibility, blame, and how the law actually works.
So picture this scenario for a second. You're walking down the street and you spot a hazard. Maybe it's a really precarious object about to fall or, a heavy gate left wide open right next to a busy road. Now, you didn't create this hazard. You have absolutely zero connection to it. You simply look at it, turn around, and walk away. If someone gets hurt because of that hazard, can you actually be sued for simply doing nothing? I mean, when exactly does just standing by become a punishable offense under the law?
To figure that out, we need to get our terms straight right off the bat. Tortious liability for omissions refers to the legal responsibility and the very real potential for being sued when a failure to act, which is an omission, causes harm or loss to somebody else. Basically, it's the legal consequence of your inaction. Okay, let's dive into this. Here's our roadmap. Number 1, the liability of doing nothing. 2, early exceptions around assumed duty. 3, controlling third-party actions. 4, holding public authorities accountable. 5, the modern Robinson precedent. And finally, why all of this matters today. We're going on a bit of a historical ride here, a 70-year legal journey, to be exact. We're starting from the immediate post-war period in 1948, and we're going right up to a massive Supreme Court ruling in 2018. We're literally going to watch the law evolve in real time, all through the lens of human error and some highly exceptional circumstances. Section 1, the liability of doing nothing, understanding the general rule. So the law has to start somewhere, right? And English law starts with a surprisingly rigid foundational rule. Generally speaking, there is no tortious liability for pure omissions. A pure omission means you literally just failed to act with no prior connection to the situation whatsoever. So if you see a stranger drowning and you aren't a lifeguard, the law doesn't legally compel you to jump in. Doing nothing is usually not an offense. And that's exactly what makes the cases we're about to look at so dramatic, because they are the rare, defining exceptions to this incredibly strict rule. Section 2, early exceptions. Assumed duty, when doing nothing becomes your fault. It really didn't take long for human circumstances to start bending that rigid rule. Take the 1948 case of Stansby v. Troman. A decorator was hired to work on a house. He leaves for a bit to get some supplies, and he completely fails to lock the front door. He just pulls it shut. During that time, a thief walks right in and steals the homeowner's property. Now, the decorator didn't steal the goods, he just omitted to lock the door, but the court established liability anyway. Why? Because by taking on the job and being left alone in the house, he had assumed a duty. His omission wasn't a pure omission anymore, it was a failure inside a relationship of assumed responsibility. And we see this concept totally cemented just a few years later in 1955 with Carmarthenshire County Council v. Lewis. In this one, a young child wandered out of a school through an unlocked gate. Tragically, a lorry driver swerved to avoid hitting the child and lost his life. The school obviously didn't tell the child to run into the road, they simply omitted to supervise him properly and secure that gate. But because the school had assumed a duty of care over the child, their failure to act, their omission, made them fully liable for the resulting harm. Let's move to Section 3, controlling third-party actions, responsibility for others. Okay, this brings us to a massively famous 1970 case, Home Office v. Dorset Yacht Company. The facts here are almost cinematic. Borstal boys, youth offenders, were taken on a training exercise to an island. The guards, rather unhelpfully, decided to fall asleep. The boys escaped, boarded some nearby yachts, and ended up crashing them. The yacht owners sued the Home Office. Once again, the guards didn't crash those yachts. They just slept. But because they had a high degree of control over a specific group of people who were known to be a risk, their omission to guard them directly led to liability. And this brilliantly illustrates the nuance of the law when we contrast Dorset Yacht with a later case, Smith v. Littlewoods from 1987. In Littlewoods, the defendants owned an empty cinema. Random, unknown trespassers broke in and started a fire, which then spread and damaged the neighboring property owned by Smith. Smith argued, hey, Littlewoods omitted to secure their empty building. But the court said, no liability here. Why? Because unlike the guards in Dorset Yacht, who had total control over specific, risky individuals, Littlewoods had absolutely no control over random trespassers, and the fire wasn't highly foreseeable. The difference between these two precedents literally just comes down to that level of control over the third party.
Section 4. Holding public authorities accountable. The emergency services. So let's look at two really crucial cases from the mid-90s. In the 1996 case Stoven v. Wise, a local council knew all about a bank of earth that was obstructing a very dangerous road junction, but they omitted to remove it. A crash happened. The court ruled the council was actually not liable. It was a pure omission of their statutory powers to improve something. But compare that to Capital and Counties v. Hampshire County Council, which happened just a year later in 1997. A fire brigade arrived at a fire and incredibly ordered the building's sprinkler system to be turned off. This actively made the fire spread way faster and it destroyed the building. The court found them liable. They didn't just omit to put out the fire. Actually, scratch that. It's more like their intervention made the whole situation actively worse. Section 5. The modern Robinson precedent. The 2018 climax. So the crucial point is what happened in 2018. The Supreme Court heard the case of Robinson v. Chief Constable of South Yorkshire Police. An elderly woman was knocked over and injured by police officers who were trying to arrest a suspect on a busy street. For years, there was this widespread belief that the police had a sort of blanket immunity from being sued for negligence while doing their jobs. Well, the Supreme Court used this case to completely shatter that myth. They clarified that public authorities, police included, are subject to the exact same rules of tort law as ordinary citizens. If the police cause harm by a positive act, they can absolutely be liable. But they also reaffirmed the omissions rule. The police don't generally owe a duty of care to protect individuals from harm caused by criminals, unless, of course, they have assumed a specific responsibility to that person. It definitively set the modern test for when an omission is actionable.
Section 6. Why omissions matter today. Connecting the precedents.
Ultimately, the law is a slowly evolving organism, bending a rigid rule by exceptional human circumstances across 7 decades. I mean, we went from a decorator leaving a door open in 1948 to a school gate in 55, escaping youths in 1970, all the way to a bustling street arrest in 2018. The baseline rule remains exactly the same. You usually can't be sued for just doing nothing. But as we've seen today, the moment you assume a responsibility, or you take control of a dangerous situation, or you step in and accidentally make things worse, that shield of pure omission, it completely vanishes.
So, as we wrap up this explainer, I really want to leave you with a lingering thought. Based on all these precedents, what is your true legal duty to your neighbor? Next time you see a hazard and you consider just walking away, maybe ask yourself, have you unintentionally assumed a responsibility? Because as the courts have shown us over the last 70 years, sometimes doing nothing is literally the most legally consequential thing you can possibly do. Thanks for learning with us today.